Welcome to Transnational Competition Law course, and dear learner, we have discussed with you that competition law in Brazil in a broader term of reference of the contribution of the competition law in BRICS country in constructing the entire discourse on the transnational competition law. And we have noted the fact that in the very conspectus of the transnational competition law happens to be very interesting if we look at the entire development of competition law policy and enforcement in the BRICS country. Dear learner and viewer, you might recall vividly that we have discussed about the competition law in Brazil. What we discussed, that we tried to see that how the constitution of the Brazil happens to be very progressive sounding in terms of encapsulating the concerns for the competition and the market. Besides curbing to the monopoly, we have taken note of the Constitution of Brazil of 1946. We have also taken its consequent amendment in 1967 and the constitutional amendment of 1969. We have also referred to some of the very numerous provisions of the Constitution of Brazil of 1998 with a special reference to Article 170 and 173 subclause 4 subclause 2, and we referred to ultimately the Brazil Constitution of 2001, especially the Article 2, Article 145, Article 155. We also took note of Article 146 and Article 155 in constructing that what happens to be the constitutional conscience to the competition under the Brazilian constitution. We also try to understand what exactly happens to be the connotation of the social functions of property, which has been underpinned under Article 170 of the Brazil Constitution of 1998. Then, having discussion on the Brazilian Constitution, we refer to the classical competition law which are prevalent in Brazil. We notice that the decree law of 869 of 1938 happens to be the one of the four, the first competition law in technical sense, and we have a Brazilian competition law in 1945. Vis-a-vis, we have a Brazilian antitrust law enacted in 1962 and which has created what is called Conselho Administrativo de Defesa Econômica, shortly known as CAD, derived from the Portuguese acronym, and then it is commonly known as the Administrative Council of Economic Defense, the CAD. We also refer to some of the auxiliary and supplementary law which has given the shape to the competition law in Brazil in matters of the classical competition law. And we have construed that there exists a classical competition law as well as we have a neoclassical competition law. And in the neoclassical competition law, what we find that in the classical competition law, we find that besides creation of the CAT, there happens to be the Economic Law Secretariat, there happens to be the Secretariat of Economic Policy, there happens to be the Economic Law National Secretariat, Economic Policy under the Ministry of Finance, and the Secretariat of Economic Monitoring. So what we see that the antitrust measures which has been underpinned into the constitutional conscience of the Brazil vis-a-vis the very principles of the free enterprise and the open competition and the social role of the property in consumer protection and restraint of abuse and the economic power serves as a guide. Then we refer to the neoclassical competition law, and we have referred to especially the 1962, the antitrust law of the Brazil, and then we refer to some of the very important provisions of the 1994 law which have been passed in the backdrop of the new constitution and as well as heralding and ushering of the new economic policy which is called the Real Plan, which have changed the entire paradigm of the economic policies in Brazil in 1994. And then we also witnessed the creation of the three agencies besides the CAD. We have the Economic Law Office, Secretariat for Economic Monitoring, and that way the neoclassical competition law in Brazil has given rise to a large number of the body for the adjudication of the competition dispute. It was realized later that the law which happens to be existed in the name of Brazilian Antitrust Law 1994 confounded some kind of a confusion in the administrative acumen and the hierarchy of the competition dispute. Therefore, the modern competition law, meaning thereby the Brazilian Antitrust Law number 12529 of 2011, which was promulgated to simplify and consolidate the administrative competition law, and instead of the three agencies, it tries to have the General Superintendent General and the Deputy Superintendent General besides Department of Economic Studies. We have referred to Article 36, we have referred to many other provisions of the Brazilian Antitrust Law of 2001, especially we refer to Article 12, we refer to Article 6, we refer to Article 5, we refer to Article 36, and then we try to reflect how the role of the CAD as a nodal agency with General Superintendent and Deputy Superintendent has been working in ushering a, a kind of a amicable dispute resolution and having a vigil and wash to the Brazilian market in promoting the competition law. We have referred to the contribution of the CAD in relation to the reform of the substantive law. We reform in the administrative competition law, we reform in the procedural competition law, and the systemic reform which has been brought by the CAD in the modern sleeve of reform of the competition law heralded in 2011. We refer to the contribution of the CAD and judicial contribution and the quasi-judicial contribution, and then we try to see that though the CAD in Brazil does not follow the stare decisis doctrine or doctrine of precedent or to stay by the decisions to guide the future cases, it happens to be very autonomous. It tries to see some kind of a continental system. It does not believe in a common law system, and then it codified a large number of the rules for the antitrust dispute resolutions and antitrust laws and policy. We will here refer to some of the judgment we have noticed in the last lecture regarding the cartel and cartelization and the antitrust activities. These two aspects we have taken care of in the last lectures. Today, and we have taken care of the entire dispute scenario and the litigational strategy and the judicial strategy of the CAT in matters of antitrust law, in matters of anti-cartel law, and we refer to some specific sectors which happens to be the cement, the marine house, LPG distribution, medical hospital and services, air and maritime freight, and the air cargo. With this, what today we are going to discuss, dear learner, and we will try to see that how the CAD happens to be a quasi-judicial authority, happens to decide all the competition dispute, have an administrative control over the market in Brazil, and try to hone out the strategy. That strategy happens to be more tilted towards the criminal law enforcement, tilted towards the command and control approach, tilted towards the prosecutorial strategy, tilted towards the imposition of the fines and some kind of the punitive actions against anyone who happens to violate and infringe the basic precepts and the practices of the competition law. In that reference, we will go to the issue of the prosecutorial strategy and how they have advanced that prosecutorial strategy and have the criminal enforcement in many of the cases, and we will try to reflect the overall functioning and the working of the CAD in Brazil, having a very formidable institutions to be reckoned with and to be replicated in other jurisdictions and have a far-reaching ramification on the transnational competition law. Dear learner and viewer, in this respect, when we talk of the role of the CAD in matters of adopting the prosecutorial strategy, then we find that it has imposed a large number of sanctions. In December 2005, precisely the CAD fined four port operators in Porto Alegre and the port's personal management body for imposing the disproportional fee to new players and seeking to employ workers at the port. In its decision by the CAD concluded that since dealing of the OGMO was the only way to access the market, the unreasoned fee created a significant barrier to the competition. Therefore, the fine which the CAD imposed amounted to 10% of the defendant's competition, and the fine and 10 and the fine which happens to be the 10% of defendant's turnover in the year before the initiation of the investigation. Thus, we see that what in this judgment or relating to the Porto Alegre, the CAD happens to convey the strong message to the market and the firms is the fact that the punitive action to the extent of the 10% of defendants turnover in the year before the initiation of investigation happens to be an exorbitant fine, and the message is wide and clear that it wanted to bring some kind of a salutary impact in matters of enforcement of the competition law. Similarly, we see that in 2016, the CAD imposed sanction to port operators in Salvador and Rico Grande for abuse of dominance. In both the cases, in the earlier cases, we find that the Port Alegre, in this case, we find the case of the Port Salvador and the Rio Grande. What we find in both the cases, the operator charged competitors with disproportional port storage fee using their position of the monopolist in the upstream market to harm the competitors downstream. So the total amount of fines exceeded to 10 million reais, and both parties are challenging the CAT decision before the judicial court. Nonetheless, what happens to be the decision of the appellate court in that regard? The strategy of the CAD happens to be very simple and straight, that it believes in punitive action. It tries to have a command and control approach. It wanted to set the fines are to be imposed in such a way that it has a deterrent effect and it creates some kind of a salutary changes in the market, so that the abuse of dominance, the anti-competitive activities, the predatory pricing and the price fixing, and the cartel and cartelization issues and other forms of antitrust law violation should be brought to the book. In that sense, we see that there are many settlement once the CAD happens to impose a heavy fine, but all the time it is not leading to the fine, but sometime it so happens that it result into some kind of a settlement, and even the CAD happens to be in agreement to any kind of a settlement which happens to be in monetary and pecuniary settlement. Then in that case we see that in 2015 again that a signed settlement was taken place in Rodimer Transporters and Equipmentos Industries and Armazens Grace in connections with an investigation on whether the point was whether the company violated antitrust law by charging customers with an additional fee to release cargo. This was the bone of contention in this case, and then we find that Roddy Rummer committed to pay 15,000 reais, implement an antitrust compliance and program and adopt an open door policy for antitrust authorities. In that way, we see that we have an entire list of imposition of the fines and the settlement. We see in cases of the CRT, in cases of a DRM, in cases of the IT industries, in cases of the coating and composite resins, in matters of LCDs, laundry services, ambulances, underground and underwater cables, and compressors and plastic bags. It has realized a heavy and very hefty amount of the settlement, and which runs a very astronomical figure. So thereby we see that it's not only the kind of a sanction and the fines which has been imposed by the CAD in cases of the Port Alegre case, or for that matter the Port Salvador and Rio Grande case, but that fine happens to exceed 10 reais of both the parties, meaning thereby what the analogy they have introduced in this case, that the fines imposed amounted to 10% of the defendant's turnover in the year before the initiation of the investigation. That was the thumb rule which was applied for the realization of the fine. So that is also something very important, that how they try to measure, how they try to actuate the realization of fine, and for that they also happens to be, the CAD happens to evolve a very handy formula of imposition of the 10% of the defendant's turnover in the year before the initiation of investigation as a yardstick to impose the fine. Besides that imposition of the fine, we have seen that in 2015, at many cases of the Rodimer transporters and Equipmentos, Industria, and Amazon Garage, we find that the court lead to some kind of a settlement, and that settlement happens to be that uh, happens to be a hefty amount and a very astronomical figure across all kinds of the industries. Therefore, what we see that in 2015, but there are many cases where the CAD declined to settle a court case. That example is the Santos Brazil, and the company was sanctioned by the CAD in 2005 for imposition of a fee known as terminal handling charges 2, and thereby what we see that the terminal handling charges which they have imposed instead of settlement, meaning thereby this is not a jacketed formula that the CAD happens to always impose the fine and always goes for settlement. It depends upon the gravity of the circumstances. It depends upon case to case approach. And then when we finally see the defendant challenge CAD decision before a federal court, and Santos Brazil proposed to pay the fine, but the company did not agree to cease the conduct, that is why the CAD rejected the proposal. So the CAD happens to see that the prosecutorial and the settlement strategy works as an standing mandamus kind of the quasi-judicial or judicial remedy. And that way the CAD's impact happens to be very far and wide. With this, dear learner, we feel that when we try to appraise the role of the CAD as an institution, we have to look some kind of the approach of the CAD which pertains to the regime of sanction, the regime of the settlement, and the regime of sanction and settlement goes hand in hand, and the CAD tries to see that how antitrust law are to be better administered and better adjudicated, not relying on one thumb rule or one jacketed formula, but have a kind of the mixture, a kind of a combinations of the various kinds of judicial approach, and that will help us to understand that how actually in matters of transnational competition law or the extraterritorial application of the competition law, the CAD has a very pivotal role to play and try to guide the other jurisdiction of the world in matters of transnational application and enforcement of the competition law. With this, I conclude, and I hope and I wish a happy learning to you.